First time we've dealt with this person.
First time?
Mm-hmm. Yep.
Well, I guess it's time. This meeting of the Escambia County Board of Adjustment for May 18, 2022 is hereby called to order. With 4 members present, we do have a quorum. Will clerk please swear in members of staff?
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
The board has previously recognized staff as expert witnesses. Does anyone have any questions regarding the qualifications and the abilities of the expert testimony? Seeing none. The BOA meeting package for May 18, 2022 has been previously provided to board members. The chair will now entertain a motion to accept the BOA meeting package into evidence. Do we have a motion?
So moved.
Ms. Bass moves.
I second.
Second by Marty. Those in favor signify by raising your right hand. Passes unanimously. Do we have proof of publication?
Yes, sir.
Did the publication meet all the legal requirements?
Yes, sir.
Chair will now entertain a motion to waive the reading of the legal advertisement. Do we have a motion?
I move.
We have a motion by Randy. Do we have a second?
Second.
Second by Ms. Bass. Those in favor signify by raising your right hand. Passes unanimously. Members of the board, have you reviewed the resume and transcript of the Board of Adjustment meeting held on April 2022? Upon the review and the resume of transcripts, are there any transcripts? Are there any additions, deletions, or corrections? Seeing none, the chair will now entertain a motion regarding the hearing resume of the Board of Adjustment held on April 20, 2022. Do we have a motion?
So moved.
Motion by Randy. Second?
Second.
Second by Ms. Bass. Those in favor raise your right hand. Passes unanimously. The Board of Adjustment BOA hears administrative appeals, variances, and conditional use requests. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings at a court of law, however less formal. All public testimony will be taken under oath, and anyone testifying before the BOA may be subject to cross-examinations. All documents and exhibits that the BOA considers are entered into evidence and made part of the record. The giving of opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. After hearing the testimony and documents for and against the proposed action, and before making its decision, the BOA will consider the relevant testimony, the exhibits entered into evidence, and the applicable law. Because decisions of the BOA relating to variances, conditional uses, and extensions of development order for site plan approval are final, unless overturned by a court of competent jurisdiction, the county may issue development orders and permits for the issuance of such an order or permit. County shall bear not bear any risk should the decision be set aside, the enjoined or enjoined by the court. Any applicant for a relief from a decision of the BOA for said actions or any aggrieved party as defined by state law may seek review of such decision by filling an appropriate pleading in a court of competent jurisdiction within 30 days of the BOA decision. The date of the BOA decision shall be the date the BOA voted at the conclusion of the hearing. Whenever the BOA denies an application, no new application for an identical action on the same parcel shall be accepted for consideration within a period of 180 days of the BOA decision. Any person aggrieved by a decision of the BOA relating to an appeal of an administrative decision may within 15 days thereafter apply to the circuit court for review. Each individual who wishes to address the board regarding a particular issue must complete a blue request to speak form located at the table in the back of the commission chamber. You will not be allowed to speak until we receive one of these completed request to speak forms. We must have these completed forms for public record. Any written or oral communication outside of this hearing with members of the BOA regarding matters under review today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and may be discussed as provided in the Board of County Commission Resolution 96-13 before a decision by this board on any administrative appeal, variance, or conditional use request. The chair will ask, as each case is heard, that any board members who have been involved in any ex parte communication regarding the respective issue to please identify themselves and describe the communication. Is the applicant present? You're the applicant? Okay, sir. First case is case number CU, conditional use 2022-06, 677 Bayshore Drive. Board members, has there, first of all, let me note that the minutes reflect that we now have 5 board members present. Board members, has there been any ex parte communication regarding this case? Seeing none. Does anyone have knowledge or information obtained from a site, visit, or other sources? Seeing none. Does any board member intend to refrain from voting due to a voting conflict of interest? Seeing none. Would the individuals who are party to this item please come to the podium, identify yourself, state your name and address for the record, and be sworn in by the clerk.
I'm Gilbert Hitchcock.
Please raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
And were you provided with a copy of staff's findings of fact?
No.
You were not?
Well, I just fill out the forms and then that I put in requests. That's it. I haven't seen anything since.
Okay.
We,
Well, then
that's,
without objection.
I was gonna say, that's in
then-
the email link that's sent out. It's a link to the
He
meeting
didn't see
packet.
it. Let's just
Okay.
go ahead and present the staff's findings. Is that okay?
Oh, I think I saw that. I'm sorry. I
Yeah,
didn't see
yeah,
that,
no worries.
that email.
Okay,
You may have a seat while he presents, and then
Yeah.
if you have any questions.
so, you wanna do the maps? Let's do the maps. So this is, conditional use case 2022-06. This is our location map. The 500-foot radius zoning map showing the zoning as high-density residential. The mixed use for the site is mixed use urban. Here we have an aerial map of the site. As you can see, it's a rather deep lot that fronts on Pensacola Bay. Public hearing sign that was posted on site. That is looking south into the subject property. Looking west along Bay Shore across the front of the property. And looking east along Bay Shore at the front of the property. So I'll go to the findings now. Applicant is seeking conditional use approval to locate a detached garage in the front yard of a waterfront lot. This is found in LDC section 4-7.3 A4B. Says that accessory structures may be located in the front yard of a waterfront lot if the structures are at least 60 feet from the front lot line and granted conditional use approval by the Board of Adjustment. As to the first criterion, general compatibility. This parcel is deep, 460 plus or minus feet, and narrow, 48 plus or minus feet. Property fronting Pensacola Bay. The proposal calls for a single-family home to be built at the rear facing the water. The garage is proposed to be approximately 370 feet from the front from the right-of-way line and would be compatible with similar properties in the area. Criterion B, facilities and services. Facilities and services for the home are available and will accommodate the addition of this residential unit. C, circulation. The site plan submitted for this case shows a shared driveway connection to Bayshore Drive, along with maneuvering room connecting the house and garage. Nuisances and hazards. The proposed use should not generate unreasonable noise, glare, dust, smoke, odor, vibration, electrical interference, or other nuisances or hazards for adjoining properties and other properties in the immediate area. E, solid waste. This proposed home is within the ECUA service area for solid waste disposal. F, screening and buffering. Screening and buffering between like uses, in this case single-family homes, is not required by the LDC. G, signs and lighting. The proposed lighting will be residential in nature and no signs are proposed. H, site characteristics. The parcel is spatially adequate to allow for the home and detached garage. I, these are the specific use requirements. A specific use requirement for this case is that the garage needs to be set back at least 60 feet from the right-of-way, and this proposal meets that requirement. Findings, staff recommends that the board approve the proposed conditional use as requested.
Mr. Chairman, I have a question.
Go ahead, sir.
On the map in front of us, the red triangle, or is that what is that? The red box?
Off to the west side? Where it says
Yeah, where it
commercial?
says white caps.
Oh, that is the property boundary. That's the parcel boundary.
And so that's the parcel we're talking about?
Yes, sir.
Okay. All right.
Do we have a site plan showing?
We do.
House and garage?
Scroll down. There you go. You can, yeah, try to. Okay, so down here we have the bay. This is the area of the proposed home in here. This is the proposed garage, and the dark area is going to be paving. There's that shared driveway that goes out to Bay Shore.
I have a question. So the reason that we need this variance is
Conditional use.
the conditional use
Put a
to
garage.
put a garage in the front.
So accessory structures are generally not allowed to go in the front yard
Right.
of a property. The code makes this exception with the conditional use on waterfront properties only, just basically because of the nature, sometimes it's difficult to get around that
Right.
to the backyard.
Is that shared driveway, leading to, the, second proposal we have on the
Yes, sir.
agenda?
Yes, sir. Same driveway.
And the drawing is showing pavement, from lot line to lot line?
Yes. It's kind of hard. It's kind of hard to see, but I'm pretty close to it, which is allowed by the code.
Is that a outside exterior stairway that I see on the garage?
Yes.
So that garage will be 2 stories? I'm guessing?
Sure, and definitely allowed by the zoning.
Is it possible for a home to be built in the conventional manner without the necessity of the garage being in the front?
I suppose there could be a way found to do that, to have the driveway extend around the house to the rear. Remember, this is a conditional use, so we don't have that same requirements as we do in a variance with it being a hardship on the land and the minimum necessary to use the property.
Well, that was my question, is whether when I was reading these files last night, I guess I wondered whether or not this is a convenience for the applicants, or is it a necessity that it be cited the way, the buildings cited the way that they are now?
So, once again, with it being a conditional use instead of a variance is based on needs, not wants. A conditional use request is want, kind of thing. So it's not, there is no other way to accommodate this. It's, here's what we're proposing that we want.
I guess then, when we hear from the applicant, maybe these questions aren't really.
Sure.
I mean, you don't know what the applicant thinks or wants or whatever.
Correct.
And so probably these are better applicant questions than staff questions. But that was my concern when I read this, again, was whether or not this is really something that, it's one thing to deny the use of a person's property. That's something that is not right at all and denies a person rights. It's another thing to fulfill a wish. So, anyway, Mr. Chairman, I hope we would, I'm sure, get more into this.
And that's why this exception is written into the code for waterfront lots specifically. We can,
Has the house already been built? Or is this,
no.
It's in
It-
progress.
You might get to the
come to the
mic,
microphone.
sir. I'm sorry, we need to record you.
The house is permitted, both houses are permitted, and the one house is about half done.
If the garage was attached to the house, would we have to go to a conditional use?
No.
Which home, you said you've already got construction going on one?
Yes.
Which address is the one that is,
677
okay,
is under construction.
all
The
right.
walls are up for 2 stories and just have to put a roof on it.
Is it for the garage or for the house itself?
The house, I wasn't permitted for the garage because we had to go through this process.
Okay, all right.
I have a
Does the
comment.
applicant have any questions of staff?
I don't, no.
Okay. Does the board have any questions of staff? Does the board have any questions of the applicant? I do not have any blue speaker forms signed and given to me. Is there anyone who did not fill out a blue form who desires to speak? Seeing none. The chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt the staff's findings of fact. If for any reason you do not accept staff's findings of fact, please go through all the criteria and address each one specifically as why you do not concur with staff's findings. We're open for a motion.
I move we accept the staff's recommendation.
We have a motion by Randy Punson. Do we have a second?
Second.
We have a motion by Marty Shack to the motion. Any discussion? Those in favor signify by raising your right hand. Passes unanimously. You may just remain, and you remain sworn in, sir. And so we will now address conditional use 202206, 677 Bayshore Drive. And you were not given a copy of staff's findings of fact, so we will ask staff to make that presentation now.
Yes, but he didn't read them.
I got the email on both of them.
Okay, we still will go forward with the staff.
You want me to sit down or?
You can, we'll go through the presentation. Mr. Chairman, you're gonna need to ask about ex parte communication and site visit for this case as well.
Oh, I know. Board members, has there been any ex parte communication regarding either of these applications?
No.
Seeing none, thank you, sorry about that.
This is conditional use CU 2022-07. This is the location map. The 500-foot radius map showing the zoning is high-density residential. As you can see, this is immediately adjacent to the previous case. Future land use for the site is mixed-use urban. This is an aerial of the site. This is the public hearing sign for this case, posted on site. Again, looking south into the subject property since they're next to each other. Looking west along Bayshore. And looking east along Bayshore, on the front of the property. As to the findings on this one, hang on. Make sure I got the right one open. Okay, findings for CU 2022-07. Once again, applicant is seeking conditional use approval to locate a detached garage in the front yard of a waterfront lot. Same code section, same reference. As to the criteria, A, general compatibility. This parcel is a deep 470 plus or minus feet property fronting Pensacola Bay. The proposal calls for a single-family home to be built at the rear facing the water. The garage is proposed to be approximately 335 feet plus or minus in from the right-of-way and would be compatible with similar properties in the area. B, facilities and services. The facilities and services for the home are available and will accommodate the addition of this residential unit. On-site circulation. The site plan submitted for this case shows a shared driveway connection to Bayshore Drive, along with maneuvering room connecting the house and garage. D, nuisances and hazards. The proposed use should not generate unreasonable noise, glare, dust, smoke, odor, vibration, electrical interference, or other nuisances or hazards for adjoining properties and other properties in the immediate area. E, solid waste. The proposed home is within the ECUA service area for solid waste disposal. F, screening and buffering. Screening and buffering between like uses, in this case single-family homes, is not required by the LDC. G, signs and lighting. The proposed lighting will be residential in nature and no signs are proposed. H, site characteristics. The parcel is spatially adequate to allow for the home and detached garage. I, use requirements. A specific use requirement for this case is that the garage needs to be set back at least 60 feet from the right-of-way, and this proposal meets that requirement. Findings. Staff recommends that the board approve the proposed conditional use as requested.
This is a bigger lot than the last one, right?
If you would.
This lot is twice the size of the other lot. It's,
That's what I thought.
and the house is also larger.
It says parcel A on this site plan. Is parcel A the other piece of property, or is it an easement?
That's the other property over
That's the other property, okay.
I see where, I guess, the darkened area is the shared driveway, right?
Correct.
And then that leads out into an area and then over in the corner, I presume that is the proposed site for the garage.
Correct.
And all that center section before you reach the home, is that paved or is it grass or what?
That's a paved driveway for turnaround for emergency vehicles and anybody that wants to drive down there.
So everything from the garage to the street is trees and woods, right?
It's trees right behind that detached garage,
that-
all the way to the street.
Yeah. You won't see any of this from the street.
No.
Board, any further questions of the applicant?
Drew, would you scroll down a bit so we can see the dimension from property line to the garage? Thank you. So we're 335?
Yes, sir.
I assume that shared driveways are acceptable. I'm just wondering why the bigger lot doesn't have the driveway.
The driveway was already on the property, and when we divided it, and I just soon not take any more trees down. And we could move the driveway over, but, and run it right down the property line. But I think this is, we're not doing anything with the other part of the lot.
Thank you.
Well, this home would be, I mean, it could be placed so that it would be in the conventional manner. It seems, you do have a bigger lot, and you've got a good deal of space, as it's shown on the drawings, in the proposed arrangement that you have now. Had you considered that?
Yes, the architect and I talked about that. We could have made a 4-car garage. I think the house needs 4-car garage, and, but we thought this would be more pleasing and nicer for the other thing is that there's gonna be a apartment above it for, guests or, mother-in-laws or whoever wants to use it. And, we didn't want that connected to the house.
So the house has a garage also?
It does. Both houses have their own garage.
So this isn't primarily to garage the cars connected directly to the home. In other words, the homeowner could pull into his home and the residence and have a garage there too, if I understand what you're saying. Is that right?
The home has an attached garage.
Has an attached garage. And this structure that we've been discussing is kind of like a mother-in-law, potential chauffeurs,
We
Sort
labeled
of.
it as a carriage house.
carriage house situation.
And, but we didn't want it attached.
And it was reviewed with those requirements in mind as well. This section of the code strictly says accessory structures. So we review it as the physical building itself.
So if
But
it was
we
attached,
double-checked.
if it was attached, we wouldn't be here talking about this?
That is correct.
Okay.
In theory, you could, I presume, keep your boat there in that structure, I would think. Is that right?
Correct. It's a structure. It's simply,
And I presume if it has living quarters, it's going to have to meet the code for actual, as a residence too, is that right?
as an accessory though, accessory to the primary. That's all part of the,
And this situation is, if I'm understanding, and please help me, this situation is different from the last case in that the last case was actually, that structure was needed as a garage. Am I right on that?
so this is a garage. It's proposed to have an apartment type thing in the,
Right.
above the garage. Once again, for the conditional use, it says accessory structure.
Right. Was the
so-
other one also then did you plan to use it as a kind of carriage house situation
It's
too?
a carriage house also.
So for our purposes, does the use matter? I mean, it's just an accessory structure in the,
So if it's got a residential use attached to it, which the first one didn't, but I reviewed both of them the same, it has to meet the regular building setbacks, and both of these do. The issue on this is that structure, that detached structure in the front yard. That's what we're coming down to.
and it's 300 feet of woods from the
300 odd
street.
feet of woods from the
From
street,
the
yes, sir.
yes. I walked past this the other day. You won't see any of this from the street. And there's plenty other houses on the same street that have the same situation. So,
Board members, any questions of the applicant? Board members, any questions of the staff? I have no speakers noted. Is there anyone here who wanted to speak and failed to register? Seeing none. Chair will now entertain a motion regarding this item. In your motion, please state whether or not you adopt staff's findings of fact. If for any reason you do not accept staff's findings of fact, please go through all the criteria and address each one specifically as to why you do not concur. Do we have a motion?
I move we accept the,
A motion by Mr. Punson. Do we have a second?
Second.
Second by Marty Shack. Any discussion? Those
Mr.
in favor signify by raising your right hand. Oh, sorry, sir.
My only thought about this is we are really also talking about additional living quarters. That was I didn't realize that it would be used for as also a residential facility. That was and so well, that was just my thought on that.
Any other comments? If not, we will go to the vote. We have a motion to approve. We have a second to approve. Those in favor signify by raising your right hand. Passes unanimously. Thank you, sir.
Thank you.
Any old business? Any new business? Seeing none without objection, we stand adjourned.
All right.
Do you know, sir, if we have cases next month?
I believe we have one conditional use that's been
case.
submitted.
What was that?
Counselor, do you know?
I
if the,
don't remember exactly. Give me a second and I'll pull it up.
Appeals to circuit? It is.